Good afternoon, everyone. This is Steve Smith of SCORE Fairfield County, and welcome to today's webinar, Social Media and the Law. Our presenter today is Cliff Ennico, who I'll introduce formally in just a minute, but I must do the obligatory comments about SCORE. Many of you, I recognize a couple of the names of folks that are in the meeting already. So some of you will know this, but I just want to reinforce the fact that SCORE is a national organization, been around since the 60s. There are, believe it or not, 320 offices around the United States. That certainly should be enough. And we have more than 11,000 volunteers. In Fairfield County, in Norwalk on East Avenue is our location. We have around 100 volunteers, sometimes a few more, sometimes a few less. And what we're really trying to deliver in the marketplace is industry expertise, business process expertise, subject matter experts, and we do that through a series of workshops, webinars, one-on-one counseling, and mentoring. The one-on-one counseling we primarily do at our office on East Avenue, but we also can do it in a location of your choice. We can do it via Skype. We'd also do it via email. Try to be very flexible there. And if you're interested in one-on-one counseling, go to scorefairfieldcounty.org, and this is important, scorefairfieldcounty.org. And you have all the options. And actually, you'll be able to see there everything I'm saying and probably more. The other thing that we're doing, and you're a part of it right now, is workshops and webinars. Our workshops are held in general at local venues, primarily libraries like Westport, New Canaan, Norwalk, etc. And then the webinars, which is exactly where you are today, a program we started at the beginning of the year. It's been very successful, and we're expanding it. We think it gives you the flexibility to do something over lunch to enhance your business acumen a little bit easier than driving somewhere at the end of the day where most of our workshops you would have to do. Let me just make a comment about our next webinar. It's going to be 2 weeks from today, October 25th, and Kate Berg, who is a very close associate of SCORE Fairfield County, will be our presenter. And the subject is marketing to your mobile customers. You can't get much more topical than that. So, again, look for the specifics of that workshop at scorefairfieldcounty.org. Thank you. We're going to stop this webinar at 1 o'clock sharp to respect everybody's time. You'll notice if you look at your screen that there's a chat room down at the bottom left-hand of the screen. And so I'd encourage you to log your questions down there. I'll moderate the chat room when we get to the end of Cliff's presentation, which should take 45 minutes or so. So we've got some time for questions. That's always very important. So on to Cliff. Cliff is a great friend of SCORE Fairfield County. He does a lot of work for us, but in his real life, he's an attorney. He's a lot of things, and every time I introduce him, I think, wow, this is a busy boy. The author, a syndicated columnist, a speaker, television personality, and a humorist is the part I like even the best. He's one of America's foremost small business experts and has helped more than 15,000 small businesses get off the ground over his past 35 years. He's a former Wall Street lawyer, which we won't hold against him for long, and a business development consultant. He's author of 10 books and is also a big star on YouTube. And, in fact, I think there's some people from Johns Hopkins University on the phone now who found him via YouTube and are going to be learning what Cliff can pass on in the next 45 minutes on social media and the law. So, Cliff, I'm about ready to turn it over to you. And, again, we'll go for 45 minutes. Then we'll have some Q&A, and then we'll try to shut her down right at 1. Okay? All right, Cliff, it's all yours. Please take it away.
All right. Well, thank you very much, guys. It was a great introduction, and welcome to everybody. First of all, congratulate yourselves on being so disciplined that you are willing to take out an hour of your life on at least what's here in New England, an absolutely beautiful fall day, to listen to a lawyer yam around about social media and how it can get you into trouble. Not a lot of people would do that. You should be congratulated for your fortitude and for your buns of steel. My name is Cliff. That's the only name I go by. And let's just launch right into this. First of all, now, if you ever doubted that I was a lawyer, this will prove that I am. We always tell you what we're not going to do before we tell you what we're going to do. Obviously, you know, I am very much a friend of SCORE. I am not in any way affiliated with SCORE. So obviously, whatever I say, you know, they can. You know, if they don't like it, they can certainly disclaim it. But the more important disclaimer is the second one, which is, while we are going to get into some legal and tax stuff in this program, and I will do my best. I know some of you have some very specific questions you want to ask me. I'm more than happy to answer them. But you have to understand that none of what I say on this program should be relied upon as one-on-one legal or tax advice. There's a very big difference between saying this is what the law says and this is what you should do. And I'm really not in a position to do the latter, at least not unless you retain me and you pay me something and I get to know you a lot better than I possibly can on a 45-minute program, no matter how good or how thorough it is. Okay, so let's begin. What is social media? If you're looking at some of the older articles on this, they refer to it as Web 2.0. It's basically a category of websites that is based on user participation and user-generated content, or as one of my friends refers to it, the bastard stepchild of a website and a blog incorporating the worst elements of each. The key is a social media site, a Web 2.0 site, is interactive and it's sometimes public. Up until the early 2000s, websites were one-dimensional. If I have a website, a Web 1.0 website, a non-social media website, I'm just talking to the world at large. The world at large cannot talk back to me. So, for example, if you look at my cliffennico.com website, which is the website that I use for my law practice, it's just nothing more than a marketing brochure. There's a photo up there that has been a little bit photoshopped. That's okay. And I'm a little vain that way. What can I tell you? And I have the list of some of the stuff I do for people, what I don't do, what my price list is. But there's no way that you can interact with that website. Or you can send me an email if you want to. Hey, Cliff, I want to talk to you. Let's schedule a time. But there's no dialogue going on here. A social media website is two-dimensional. Not only am I talking to you, but you can talk back to me, and also you can talk to other people who are participating in the site. A social media site is interactive, which legally is very interesting. In a traditional website like my cliffennico.com, I only have to worry about the legal consequences of what I'm saying on that website. I only have to worry about my content. On a social media site, a Web 2.0 site, I not only have to worry about what I'm saying, but I also got to worry about what you are saying and what other people are saying on the site. Can I be liable for what other people are doing on my social media website, sometimes without my knowledge? It's a very fascinating legal question, and we're going to give you some of the answers here on this program. First of all, these are just some examples of social media sites. I'm not going to spend a lot of time here. You know about all of these. Most of you probably have presences on every one of these, to be honest with you. So we're not going to spend a lot of time on this. I sometimes give this talk to corporate executives who aren't as familiar with the social media universe, so this is a very valuable slide. But I assume you know the difference between Twitter and Instagram, for example, so I don't think I have to spend a lot of time on this. Social media is for real. I'm going to share with you two stories about social media. So it's something I probably should have done at the very beginning. But to give you an idea of how powerful social media is, I have to be honest, when social media first started coming out in the early 2000s with Facebook and Twitter and some of the early social media sites, I wasn't a big fan. I didn't really see the benefit there. I just figured, it's just one more way to waste some time on the Internet. And by the way, social media can be a time vampire. We will talk about that a little bit later. You could easily spend all your time keeping your social media sites up to date. It's very easy to do, and obviously it's not the best and highest use of your time. We'll talk a little bit about how you allocate your time between some of these things. Basically, you spend your time on the things that are working. But I will share with you, I myself had a very powerful experience just last year, actually. Last year was the first time I really got social media for the first time. Back in December of 2013, I did a SCORE program up in upstate Connecticut. It's a very popular program. I've been doing it for years, called How to Sell Just About Anything to Just About Anybody. It was in an old corporate headquarters room. The corporation had left there. It was this big cavernous room. They set up about 100 chairs, and I think we had maybe 10 people in the audience because it was in one of those corporate office parks that go on forever, and I think nobody could just find the place where we were. But they had a TV camera there. The local community television station was going to video this. They asked me if I was okay with that. I said sure. So I did this presentation, and didn't really think anything of it. The woman who hosted the program said, well, just so you know, we're going to take this. It's going to be on community TV, but we may also put it. We're trying to set up a YouTube channel, for our local SCORE channel. We want to put it up there. Okay, fine. Happy to do it. Don't mind that. It's an hour and 15-minute lecture. It's very long for YouTube, but didn't think anything of it. Right. So that's it. Fast forward about 5 or 6 months ago, I hired a social media marketing person to help me sort of get all my stuff together. I had a Facebook page for years, but I wasn't doing anything with it. I had a Twitter account, but I wasn't tweeting. Interestingly enough, I actually had 800 followers, and I had never posted a single tweet. I think that has to be a record or something for Twitter anyway. So I hired this lady about 6 months ago, and I said, just take a look, search for Cliff Ennico online. I got a bunch of stuff out there. Just let's pull it all into one place. Let's try to make it work as a social media presence. So later on that day, she calls me back, and she goes, Cliff, are you sitting down? And I said, yeah, sure. Why? What's going on? She goes, take a look. She sent me a link to YouTube, to a YouTube page, and I go to it, and it is this lecture that I gave in December 2013. The talk had over 100,000 views. Between December 2013 and October of 2015, more than 100,000 people had sat through that 1.5-hour lecture on how to sell from a lawyer. That blew me away. I have to say, when you have an experience like that, you see the power of social media. But now, it's not all good. I'm going to tell you another story, and this is also a true story. I'm not going to mention names. But about a year ago, there was a young lady who worked in Los Angeles. She worked for a public relations firm, a PR firm. And she and her family lived in South Africa. So last year, she flew to South Africa to spend the holidays with her family. And to get from L.A. to South Africa, you have to go on 2 very long flights. You need to take about a 12 to 14-hour flight to get to London's Heathrow Airport, and then you have another 12 to 14-hour flight to get down to Johannesburg, Pretoria, wherever the big you're flying halfway around the world, basically, and it takes a long time. So she did the first flight, and she had worked a long day. She hadn't slept at all. She wasn't able to sleep on the flight. She got to Heathrow, and she was just, tweeting, and she did something silly, something, though, that we probably all would have done thoughtlessly. She was exhausted, but she made a comment. Someone had tweeted a comment, and she responded to it in a way that some people would have probably viewed as racially insensitive. I'm not going to be specific about it, but she just, rattled off something that some people might have found offensive. And unfortunately, when she replied to the tweet, she replied as a public tweet. She turned her phone off, boarded the plane, took some sleeping pills, and in the 14 hours that it took her plane to get from London to Johannesburg, her life melted down. That tweet that she posted went viral. It got millions of comments from people around the world saying what a racist she was, what an idiot she was, how could she possibly believe such a thing? And it didn't stop there. They not only directed the tweet to her, they also did public tweets to her employer, to everybody. The employer's website went down. as part of a denial of service attack. If you know what that is, that's where people just attack a set website with so much traffic that the thing shuts down defensively. Her employer's website was basically shut down. She was becoming known throughout the internet as the racist tweet lady, and her boss, sent her an email saying, the minute you get to the airport in Johannesburg, call me. She got there, and when she landed, she had slept through most of the flight. She did not know that any of this was going on, but she basically was the arch villain of the entire internet, and her boss fired her in the Johannesburg airport. Before she even went home to see her family, she was fired on the spot for having done this, to her employer. That is also the power of social media, the negative power of social media. If you make one mistake, or post a thoughtless tweet, your whole life can melt down in the span of only 12 to 14 hours. This woman's life was ruined in the space of 12 to 14 hours because of one thoughtless tweet. She just wasn't thinking about what she was doing. So those are the positives and those are the negatives about social media. Here are some statistics. More than 1 in 3 Americans have Facebook pages. Facebook is now the largest country in the world. They have about 1.5 billion monthly active users. China, only the world's largest country population-wise, only has 1.36 billion people. Twitter, which has been going through a rough patch lately, if you read the papers, they're looking to get acquired by somebody right now, has roughly 236 million monthly active users. This is huge. MySpace, social media sites that a lot of people have written off, quite frankly, still has over 50 million users. It's not exactly dead. As in the immortal words of Spamalot, it's not dead yet. Virtually every American between the ages of 10 and 25 is social media active. If you have a teenager or 20-something person in your house, you know what the top of their head looks like because they're always bent over their smartphones doing stuff. This is where they live their lives, is online. And this social media has a lot of implications for society. People have written whole books about this. It's a major area within sociology right now. Our lives are much more public. We're much more willing to share things with people than we ever did before. When I was a kid growing up,
Did we lose Cliff? Hello? And Budley, can you hear me?
Yes, I can.
And can you hear Cliff? No?
No.
Okay, so to those on the phone, let me just let's just hold for a second here and see if we can roust him up. Budley or Herb, you want to try to give him a call? He may be just talking away, thinking he's still on. Or I send him an email, maybe. I don't know. Just hold with us for a second here.
Sorry for the delay, folks.
The fact that he doesn't move aside, kind of in case he's aware of something. And there, Budley, there's a note from Cliff there in the chat room.
Checking.
So appreciate your patience, everyone. So, Budley, he appears to be waiting in the speaker's room.
I saw that.
Yeah.
He should be able to. Okay.
Well, believe it or not, this has never happened before. So.
Okay. Give me a moment. What's the phone number here? I don't use his phone number. I need the. Probably for the right folks.
Again, to you folks listening in, sorry for this long delay. We'll get it fixed here in just a second.
Okay, thank you. We're almost there, folks. Sorry for the delay.
Okay, everybody, am I back live?
Yes, you are.
Hey,
you are.
Wonderful. There we go. A round of applause, please, for Mr. Steve and Mr. Budley for dealing with a situation with their usual grace and keeping calm and carrying on. The joys of technology.
And thanks to the people with their patience for hanging on while we had that dead time there for about 9 minutes. So anyway, Cliff, go, man, go. Now you're really under a time pressure. We'll probably have to go over a little bit.
We probably will, and that's perfectly fine. I'm not going to deprive the audience. If people want to bow out, that's perfectly fine if they have other plans at 1 o'clock East Coast time. So let's get through the fun stuff here so that we can get onto the legal jazz, which is what people here are here to listen to this program about. Social media has changed the way we live in a very big way. Our lives are much more public. You know, when I was a kid, we were told, don't put your stuff in the street. Don't tell people your business. Now people share stuff that years ago people would have been shocked if people talked about this stuff in open forum. And maybe that's good, maybe that's bad. You decide. We are untethered to a specific physical space, but we are tethered to our technology and the internet. It doesn't really matter where we are anymore. I could be anywhere and still do one of these webinars. We all have personal brands that must be maintained. One of my favorite authors, by the way, he was a professor of sociology at one of the New York City universities. His name was Neil Postman. And back in the 1980s and 90s, he wrote several books about where technology is taking us as a society. And all his books are worth reading, by the way. My favorite is a book called Amusing Ourselves to Death, about how everything has become entertainment. Everything, journalism, politics, nothing is taken seriously anymore. Things have to be dramatic. They have to be funny. But my favorite book, at least for this program, is one that he wrote shortly before his death. Sadly, he died in 2001. But it was called Life the Movie, about how when we are in, and he was writing about the early internet of the 1990s, and he said that when people are in a public space, they act differently than they would normally. They create a persona, and it's the persona that people see online, not necessarily who you are. If you know anyone who acts a different way online than they do in real life, you know what Neil Postman was writing about. A wonderful book, by the way. I'm sure you can find a copy online for cheap. We all believe we have something to say or share. Basically, social media is a publishing forum. When I'm doing stuff on my Facebook page, I am publishing my views to the world, whatever they may be. But do we all have something? Do we have things that are unique to say? Show me a suburban teenager anywhere in the United States, and I will show you somebody who has the same issues as just about every other suburban teenager in the United States. Is what they're saying really unique to their situation? Sometimes yes, sometimes no. Big implications for our political system. We believe the crowd knows more than individuals do. How many of you have bought a book on Amazon because you read the consumer reviews and you liked what you saw there, even though these people may not know anything about what the book is about? We tend to think that the crowd is wiser than individuals, to the point where your social media currency is reputation and perceived expertise, regardless of your experience. When I apply for speaking engagements now, a question I am always asked: how many Twitter followers do you have? How many likes do you get on Facebook? Now, don't get me wrong; they still care about my expertise, and what I know, but people also want to know how popular are you? Are you trending? Is a question I have actually been asked, meaning Twitter. Somebody wrote a book a couple of years ago called The Death of Experts. That's the title. I can't remember the author's name. But if you get a chance, read this. People do not believe in expertise anymore. It's all a question of how popular you are. Just recently, they found this kid. He was 13 years old. I can't remember some part of the country. I think down south somewhere, who actually had a legal blog that was attracting thousands and thousands of people around the country. This kid was 13 years old and he was giving legal advice to people. They shut him down, and boy, that kid probably got the hugest timeout in human history. But it just shows you what happens. People were buying into this legal blog by a 13-year-old kid. Anyway, so how do social media sites get into legal trouble? Let's talk about this. Virtually every year, the Federal Trade Commission brings an enforcement action, that's a lawsuit, against Facebook, LinkedIn, YouTube, Google, every one of the major social media purveyors gets sued every year because of violations of their privacy policy. This is like an annual ritual. In the fall, they bring the lawsuits, and in the spring, everybody settles, and in the fall, the lawsuits come back again. It's like an annual circus that we go through here. And why is that? How do social media sites get into legal trouble? Well, the biggest reason is they give away their services free. Mark Zuckerberg is on record as saying he will never charge users for a Facebook page. He will never do. Now, when you give away your services for free, that limits the amount, the ways you can get revenue. And, of course, generating revenue, sales is priority number one for any startup business, whether in technology or anywhere else. So that leaves only two places, really, where these companies can make money. They either generate it through advertising, and Facebook now is making a big play in mobile advertising, cell phone advertising, and this is regrettable, but sales of user data to marketing research companies. When you have 1 billion people with pages on the Facebook site, there is a wealth of data there that marketing research companies will pay a fortune to get their hands on. Some of you have heard the phrase big data used in connection with computers and software, and basically all that means is big data is basically a software program that helps people slice and dice all this data to get information that is actually useful. And that can predict what people will buy at various times. And all of the major social media purveyors do this. They will sell your data. Hopefully they do it in a way that doesn't identify you individually. That's what they're supposed to do. But they definitely sell the data in the aggregate to marketing research. And they all do it. Facebook a couple of years ago made some changes to their privacy policy, and they did something very interesting. They changed the name of it. They no longer call it a privacy policy. They call it a data use policy, which as a lawyer I find very interesting. We listen to language and we listen to it very closely. Instead of saying this is how we're going to be keeping your data private, what they're saying is here's how we're going to use it. We are going to use it, but here's how we're going to use it. That is a major shift in emphasis, which I find very interesting. Okay, now let's start getting into the meat of this. How do you get into trouble? What are the various ways that people can get into trouble when they're on social media? Well, clearly, one is copyright infringement. You see something on there and you retweet it. You copyright it. You steal it and you put it on your page, saying, "Hey, here's something I did." That's copyright infringement. Believe it or not, I get victimized sometimes this way. People take some of the stuff on my website. Usually it's other lawyers, believe it or not, who are the offenders. That's really sad. And they put this stuff on their website and they just take my name off and they put their name on it. That's copyright infringement. You can post inappropriate or offensive content and get sued for hate speech, like the lady from South Africa that we talked about a few minutes ago. You can badmouth people on your social media pages and get sued for libel or lose your job. In fact, this is happening so much now, there's even a name for it. It's called being deuced. Losing your job because of something stupid you said about your employer on a social media site. There's actually a word for that now. It's called being deuced. Companies can refuse to hire someone after viewing their social media pages and get sued for discrimination. I always counsel my clients not to do this wherever possible. And then lastly, you can post embarrassing content that can be used as evidence in a court of law. Let's just take a few minutes out. Let's really look at some silly stories here. Let's have a few laughs here. Here are some famous Facebook goofs. These are actual cases, by the way. The names, of course, are totally made up. Joe applied to the Social Security Administration for disability benefits, claiming that he had a total disability resulting from an on-the-job accident. The government, challenging his application, produced photos he posted on Facebook after the accident showing him riding a dirt bike in the Mojave Desert and hoisting his girlfriend over his head. How disabled was Joe? Probably not very. You got to be careful what you post on Facebook. People do look at it. These are also actual cases. Lara received 2 years in prison after posting pictures on Facebook of herself drinking and partying just days after causing the death of her best friend in a drunken driving accident. What do you think the jury thought when they took a look at that? Josh, very similar case, received 2 years in prison for DUI. The prosecutor obtained a photo of Josh on Facebook jokingly wearing an orange jumpsuit during a Halloween party and displayed it to the jury with the heading, remorseful. Be very careful. And by the way, I have to tell you something about these cases. If you're ever having a day where you really don't feel very good about yourself, where you really think that you're not the person or the professional that you should be, read some of these cases. You will feel much, much better about yourself. There are some truly boneheaded, dumb people in this world. Truly stupid. I mean, you look at these cases and you say, my God, what were they thinking, these stupid people? Seriously, it always makes me feel good about myself when I look at these cases, because not only I, but nobody I know is dumb enough to do the things that get you into the case books this way. If you're going to get into the case books, do something great. Challenge a law that harms society or something like that. Don't commit a Twitter or a Facebook goof. You will feel absolutely stupid about yourself. Here are some Twitter goofs. These are actual things. Cisco Systems just offered me a job. Now I have to weigh the utility of a fat paycheck against a daily commute to San Jose and hating the work. Do you think that job offer was extended, was withdrawn at some point perhaps? I think it probably was. A public relations consultant who said of his corporate client's hometown, I would die if I had to live there. Courtney Love, remember who she was? She was Kurt Cobain's grieving widow. Was sued for libel after tweeting that her former fashion designer had a history of dealing cocaine, was guilty of assault and burglary, lost custody of her child, and was a nasty, lying hosebag thief. From what little I know about Courtney Love, the word probably wasn't hosebag that she used in her tweet, but you can use your imagination there. By the way, only one of those things, most of that stuff, the lying hosebag thief thing was probably not defamation. We'll talk about that in a minute. Okay, so what's the law? The law always is playing catch up with the modern world. The law is always behind where technology is. There are very few cases dealing with social media. Almost all date from within the last 5 years, and mostly are from lower courts. So we don't really know what their value as precedent is. I'm always reluctant to cite to a lower court case because there's so many ways that could be changed in the higher courts. So let me tell you at least where the law is today, or at least where I think it is today. Are postings on social media private? If you put something up on your Facebook page, is there an expectation of privacy? The law is evolving, but generally speaking, a public posting and a public site is not private. You have no expectation of privacy. If you put something up on your Facebook page meant to be publicly viewed, and law enforcement authorities especially can use that against you, they have every right to. There is no defense to that. The idea is that if it's up there publicly, it is meant to be viewed by the entire world, including your worst enemies. A posting may be private if it is on a password-protected site or the site has high security settings that prevent outside users from viewing the site. We actually have such a site on Facebook. My family does. We have a Facebook site that is just for members of our family. We don't allow other people to look at it. You cannot see anything that is going on there. It's strictly for us so we can stay in touch with each other. In fact, we actually have a family committee. There's 3 of us who every once in a while will get an email from someone saying, hey, I'm related to you. I'm really a second cousin, whatever. And we actually there are 3 of us who make decisions as to whether or not somebody is, in fact, a member of our family. It's actually kind of funny how social media changes your behavior that way. Generally, I always advise my clients that social media postings should be treated the same as emails or text messages, and they can be used as evidence in a court of law. Okay? Who owns a social media posting. Okay, now we're going to talk about copyright a little bit. The original author owns the copyright. You do not have to register a copyright with the Library of Congress, with the Copyright Office. That's a myth. You can if you want to, but you don't have to. As long as you put the standard copyright notice on something, the C in a Circle, 2016 by Clifford R. Ennico, all rights reserved, you own that copyright, and you can enforce that. If somebody tries to steal your stuff and put it up on their site, you can send them a nasty note and make them take it down. The social media site, but you got to be careful though. More and more social media sites are putting in their policies, in their terms and conditions, in their users agreement, a clause that requires users to assign their copyright to the owner of the social media site. So, for example, Facebook has a provision saying that if you put anything up on Facebook, they have the right, the copyright, to do whatever they want to it, and they don't have to pay you any money, and you don't have to do a thing about it. And this is driving a lot of artists and photographers nuts right now. As you can imagine, if I'm an artist, if I'm a photographer, I definitely want to post some of my work, a reproduction of my work, on the Facebook site. But according to the Facebook's policy, they own the copyright to that, and they can do whatever they want with that. They can make lithographs, they can make seriographs, and I can't do a bloody thing about it. Now, that's not the intent, by the way. I'm not meaning to knock Facebook here. That is not what they intended. What the intent was with that clause was, if you're doing anything really cool on Facebook, and Facebook wants to sort of promote that to the entire community, is, hey, look what Cliff Ennico's doing over here. This is with his Facebook page. This is really cool. You should really consider doing it. They have the right to do that without getting my consent. Their intentions, I think, are good, but the way they worded the policy, they worded it in such a way that technically, if they wanted to, they could do a book, the 1,000 best images ever posted on Facebook. And if I'm one of the artists that did that, I can't do a thing about that. And I don't think that was their intent, but the wording does need to be changed there. They need to rethink that a little bit. It's driving a lot of art. I tell all my artist and photographer clients, don't put your stuff up on Facebook. Put it up on your website, and then on your Facebook page, give people a link to your page, to your website. That way, when they look at the stuff on your website, it's under your privacy policy, your rules, not Facebook's. Excuse me there. If you hire an employee to promote your business, by the way, a lot of people are doing this. A lot of people are hiring social media experts, like I hired, this lady 6 months ago, to help me out with my social media presence. If that person is an employee, if you're withholding the taxes and doing a W-2, the work made for hire doctrine applies. You own whatever it is they post. You don't need to get their consent or an assignment or anything like that. But if that person is an independent contractor, which most of them will be, if you're 1099ing them, that is not the case. When they do a social media posting for you, they technically own the posting. You have to get in their contract a clause by which they assign their intellectual property rights to you, to everything that they do. That has to be a part of your standard contract when you hire them. A lot of independent contractors do not put that language in their contracts. This is something you have to put in. A lawyer can definitely help you with the appropriate language. Okay. We have one question here which is kind of interesting. What are some ways that companies can avoid copyright infringement cases when using user-generated content for a promotion or contest? I'm not exactly sure what you mean by that. The question is, if you're using somebody else's copyrighted information for any purpose whatsoever, you are required to get their consent. I get these requests all the time, by the way, mostly from academics, from professors who want to use one of my articles they're doing like a do-it-yourself course book or case book for their classes, and they want to use one of my articles. I always say yes. I mean, I never charge money for that. As long as I put my name on it, I'm perfectly cool with it. But I do appreciate the fact that they asked me for consent. I mean, if they just did it and didn't tell me, again, it depends on what they're using it for. If they're putting it up on a website, a crazy person's website with all kinds of crazy theories about how the government is doing all this stuff behind our back, I'm not sure I want my name associated with that. A lot depends on what the use is. And I think that's the right answer. Generally speaking, whenever you're using somebody else's stuff, and especially, I'm just gonna fall back here for a second. Make sure whenever you take a photograph off the web, make sure you know where it comes from. A lot of photographs are owned by a company called Getty Images out in Los Angeles. They are the biggest photo bureau in the world, and they own the rights to lots and lots of stuff. And if you use one of their photos without their consent, they are vicious. They are ruthless. They will send you a nasty letter. They will charge you something like $100 a day for each day that that photograph was up on your website or wherever on your social media page, and there's ways they can find that out, and they never back down. I have never been able to get Getty Images to waive that fee for one of my clients when they goof up that way. Sometimes I'm lucky I can get them to agree to a payment schedule, but they never back down. They are like pit bulls with a bone. Seriously, do not mess with Getty Images. Those people are just horrible to deal with. Ironically, they're actually very easy to deal with if you ask them for permission. Their one-time licensing fee for a website, I think, is only something like $10-15 per photo. It's not a horrible thing. They're not a horrible company. I don't mean to knock them, but if you take one of their photographs without permission, they are utterly ruthless. Do not get into a fight with Getty Images. You will lose. Okay. A few more words about copyright and trademark infringement. You are liable. If you take somebody else's stuff and put it up on your social media site, you are liable if you commit copyright infringement. But the social media site is not liable unless it endorses a posting or solicits or induces the illegal behavior. The site has to actually endorse it in some way. The site has to basically say, yeah, you had the right to do this when you didn't. That never happens. Basically, the site is not liable. There's a law called the Digital Millennium Copyright Act. It was passed by Congress in 1998, and it basically says that a website, a social media site, is not liable for any copyright infringement that goes on the site as long as they post a takedown policy. If you look at the terms and conditions, the user's agreement of virtually every social media site, there is a section called takedown notice or DMCA notice, and this is what this is. Basically, it's a policy that says, okay, if we are if you think that somebody's engaging in copyright infringement on our site, notify us. There's a special email. It's usually copyright@whatever.com. Let us know. We will notify the person. And if they don't respond within 5-10 days to our email, we will take the infringing content down. If they do get back to us and say, no, I have the right to do it, well, then it's between the two of you. We're not going to get involved. But we will take down, as long as the person does not contest it, we will take down the infringing material as long as you tell us. That's a takedown policy. The DMCA requires every social media site to have one. If you do not have this on your website and people are doing social media stuff on your website, on your web page or website, whatever, make sure that language is there, because that's what protects you. As long as you have a takedown policy and as long as you enforce it consistently, you cannot, as the website owner operator, cannot be sued for copyright infringement because of what other people are doing. Remember, you're always liable for the things that you say and do online. None of this changes any of that law. What you're concerned about with social media is when are you liable for what other people do. One area also that you got to be careful about, don't you pick a username or hashtag that confuses people about your relationship to a trademark owner or dilutes the owner's brand. So, for example, if your name just happens to be William Gates or Bill Gates, as everybody calls you, you got to be a little careful about using the hashtag Bill Gates. You don't want people thinking that you are the Microsoft guy, unless, of course, you are. And if you're listening, by the way, Bill, hire me. Okay. You never know. With social media, you never know who's going to listen to this stuff. Remember? I got 100,000 views. I'm sure that some famous people have looked at that stupid video of me. By the way, you'll know it's the right video. If you want to check it out online, go to youtube.com, search for How to Sell, and it's the one where I'm wearing this ugly purple sweater. I sort of look like Barney a little bit. It definitely pops. It definitely stands out when you look at the search results. All right, let's switch gears now. We were talking about copyright infringement. Now let's talk about another way you can get in trouble, libel and slander. You are liable for everything you say on social media, but opinions are okay. Under the First Amendment, you have the right to give your opinion on any topic that you wish. So if you want to go on Yelp.com, and obviously here the review sites like Yelp.com, and there's one called Avo.com, which is for lawyers, and Angie's List and all this stuff. These are where all the case law is in the whole area of libel and slander. For some reason, whenever a dentist gets a negative review on social media, they sue. All the cases involve dentists. It's incredible. I don't know. There's a thing about the dental community. I won't go there. But for some reason, all the cases seem to involve dentists in this area. If you want to say, Cliff's a lousy lawyer, I hired him, I wasn't happy with the results, okay, obviously I'm not going to be happy about that. That's not the reputation I want online. But there's not a whole lot I can do about it. You are always entitled to your opinion. You cannot, that's not going to get you into trouble. There's no way I could sue you for libel or slander or anything like that. But when you make a statement of fact, Cliff has been sued for malpractice 36 times in the last year. Do not deal with this guy. That is libel if it's not true. It has to be 100% true. As long as it's true and you can prove it, you're okay. But I will tell you, in 36 years of practicing law, I have not been sued for malpractice once. I'm knocking on wood right now. May it never happen. But if anybody goes online and saying Cliff's getting sued left and right for malpractice, don't deal with this guy, that is libel. If you make a statement of fact that is not true. So do not do that. Stay away from that. But you are not liable for what other people post on your site. Okay? You are not liable. There's a section of the Communications Decency Act of 1996, Section 230. In fact, this is called a Section 230 defense. If you Google that phrase, you'll see lots of articles that have been written online about this. Basically, this statute gives absolute protection to website owners from liability for what other people post on the site. In other words, as long as the libel is being committed by someone else who's not affiliated with you, you are not liable for libel and slander actions that take place on your site. Copyright infringement, a little different. You have to have the takedown policy in order to get the immunity for copyright infringement. Here, you don't have to do a bloody thing. The statute gives you that protection. You cannot, as a website owner-operator, you cannot be sued for things that go libel unless, and this is an exception now that is starting to get a little bit bigger, unless you participate in the libel. So if someone commits libel on your site and you go in there and say, hey, you know what, we really agree with Cliff on this. Yeah, this guy is an idiot. He really doesn't belong here. He should. If you're stupid enough to do something like that, then you might be able to be sued for libel because you are now making the libel yourself. But as long as you don't do that, as long as you stay out of the chat room and not say anything, you are not liable for what other people say. Now, you should be aware the law is slightly changing here. There have been some truly horrific cases coming within the last year to 2 years. People who answer Craigslist ads for something, and they're getting raped and murdered and stuff like that. Congress is considering watering down Section 230 a little bit to make it easier for people to sue websites for allowing bad content to appear on their sites. Note that, by the way, all the dates of these statutes, 1996, 1998, these were in the early days of the Internet. The thought back then was, hey, the Internet's new. It's a brand new medium for communication. We don't want to kill the golden goose here. Let's give these website owners protection, and let's see how this develops. Let's see how the Internet grows and develops. Let's not kill this thing in its infancy. Let's see where it goes. The feeling now is that after 20 years now of experience with the Internet, we maybe can impose a little bit more liability on website owners. So look for the case law to change a little bit, and especially when the new Congress sits in on January 1st, see whether or not they want to water down some of these protections. All right. Threatening behavior. This is another way that you can get in trouble online. We actually have a Supreme Court case here. It was passed down last year. If you ever need something to, let's put it this way, if you really want something that's going to keep you awake at nights, read the facts of this case. Basically, a husband was, basically a very nasty divorce. Wife took the kids, disappeared, got a restraining order on her ex-husband, and the ex-husband considered himself a rap artist. So he went online and basically did all these rap-style poems about how he wanted to kill his wife and the judge in the divorce case. He wanted to walk into an elementary school class and start shooting up kids. Hell hath no fury like a crazy man in a kindergarten class. That's one of his exact quotes. And includes photos of him holding a toy knife to a coworker's throat at a Halloween event with the caption, "My wife, I wish." How many of you here would like to meet this guy on a dating site? Okay? Don't think I would want to. Let's put it this way. But he did something very smart. He included some disclaimers that his content was fictitious, no intentional representation to a real person. The statement, "I'm doing it for me, my writing is therapeutic, art is all about pushing the limits, and I'm willing to suffer for my constitutional rights." This case went all the way to the Supreme Court, and the Supreme Court threw the case out. They said they basically let Ioannis off the hook. He said that he didn't really intend harm, and that at least under the specific criminal statute that he was prosecuted under, the state must prove that the defendant actually intend to make a threat. As long as the person is just having fun and goofing around, and saying stuff, recklessly, as long as there's no intent to actually carry out the threat, there's no liability under the law. I hope you all sleep very well tonight. This case actually scares me a little bit. I'm not sure the Supreme Court did the right thing there, but anyway, that is the law, and it is from the Supreme Court, so it's binding on the whole nation. Okay, selling stuff on social media, we talked about this already. You can sell goods and services from your Facebook page. I tend to advise my clients against it. The better practice is to use Facebook to link to your business website and sell from there. Why? Because you can use your own terms and conditions, your own privacy policy, and if you're selling creative works, you avoid that policy about Facebook owning all rights to images posted on the site. Advertising law does apply online. Your advertising on social media has to be truthful, not misleading. Be careful when you have endorsements or testimonials. If you pay a person, a blogger, for example, to blog your products and services, that the compensation must be disclosed as part of the blog entry. So if I take money from somebody for blogging about how great their products are, I can do it. There's not against the law, but I have to disclose, just so you know, I did receive some promotional consideration. Remember, you know the tagline that they always say at the end of the game shows, the quiz shows, certain guests have received promotional consideration for their appearance on the show. You have to make that exact same disclosure when you're doing blogging for somebody else. If you have been paid for it, if you just did it out of the goodness of your heart, you don't have to worry about that. Tweeting, watch out. Tweeting can constitute spam. There's a whole set of rules on this. If you search online for Twitter and Can Spam Act, you will get whole law review articles and stuff that's been written about this. Basically, under the Can Spam Act, you can do a public tweet, but if you're directing tweets at somebody, you're not supposed to direct them to people who are not following you. That is the main rule. You can do a public tweet. You can direct a tweet to the world at ours, like the lady, the South African lady did to her great harm. But if you're sending a note to a community, you cannot send somebody a tweet to someone who is not already following you. That is considered spam. If you do that, then you must follow all the spam laws. You've got to give people a way to opt out of receiving these tweets on a regular basis, and that has to be credible. That has to be meaningful. I hate it when somebody sends me a spam email and I go to unsubscribe, and the unsubscribe goes to a dead page, an error 404 page. Okay? Okay, I'm going to answer some of the chat room questions in a minute, but I kind of want to get through this last part of this, which should only take about 5 minutes. Employees and social media. I initially did this presentation for HR executives, corporate executives, so I have a couple of slides on this. We'll go through it really quickly. Can employers look at social media pages to make hiring decisions? Yes, but they do so at their peril. I actually had this situation happen in my practice about a year ago. A company had a Connecticut branch office that was looking to hire an executive, and for some reason they didn't want to do the interviews in person. They did them all, online and all of this. So they interviewed a bunch of candidates, and they boiled it down to two people, a male and a female. And the local head of the office couldn't make the decision. They were exactly the same as far as he was concerned. So he got the bright idea of looking at their social media pages, to see if he could maybe get some extra information about them that would help him make his decision. So he goes to the woman's site first, and the woman on her Facebook page had a big announcement on her Facebook page. She just learned that she was pregnant. Okay? Then the guy said, oh, okay, that's interesting. Then he went and looked at the guy's Facebook page. And the guy also had a big announcement on his Facebook page. He announced that he was getting married to his long-term boyfriend. This was right after civil unions were allowed in Connecticut for LGBT folks. Okay, so what did the guy do? That's when he called me, after he looked at both of these social media sites and say, what do I do? And I hate to say it, but my advice wasn't too great. I had to say, well, look, no matter which way you go, you're in trouble here. The person who you don't pick is, if they find out that you looked at their social media page, and there are ways that they can do that, you're going to be facing down a lawsuit for discrimination no matter which way you go here. The best thing to do is not to hire either of them and then launch the search from scratch. And then just don't look at. I tell people seriously, do not look at social media. I mean, I know it's a temptation that's very hard to resist for most employers, but it can only get you into trouble. Only bad things can come of it. I mean, shame on you if you're not doing interviews in person or at least looking at photographs. I mean, how can you make an intelligent employment decision anyway? I don't know how you do that, but anyway, what do I know? Okay, can an employer discipline or fire or deuce an employee for social media postings? Okay, generally, here are the rules right now. Every time I have given this presentation, I have had to tweak this slide a little bit because the law is changing so rapidly. 6 months from now, it may be entirely different, but this is where we are today. Generally speaking, if an employee discloses company trade secrets or proprietary information, so for example, he goes and starts blabbing about the details of a project that he's working on, the answer is yes. The employer has every right to fire that. There are lawyers, young lawyers, who have been not only fired but disbarred for disclosing their clients' confidential information in their social media. If you are a lawyer listening to this, you do not talk about anything your clients are doing online. Okay, period. End of story. World without end. Amen. They are ruthless. When somebody is a lawyer especially, it may not only lead to your job being lost, it may also lead to you being disbarred, and you'll be working at the local Starbucks as a barista. If the employee commits libel, my boss is having an affair with a coworker, which turns out not to be true. The courts say that employer has the right to terminate an employee for disrupting the workplace. But, and this is a big but, if the employee is discussing workplace conditions or union activity, the employer cannot discipline the employee for that. There's actually a section of the Federal National Labor Relations Act that says that it's called the water cooler provision that basically says that employees have the right to gripe about their working conditions at the water cooler. It's part of their freedom of speech. As long as they're discussing workplace conditions and that kind of stuff, you can't do anything to them. They have a right to talk about this stuff, and that statute's being applied more and more in the social media context. Also, too, as long as the employer provides you with the site, and here's we got to be very careful. If you are employed by a company and the part of your job description is to post things on the company's website or the company's social media pages, you can be fired for anything that you say in that venue. However, if you make a statement on your personal social media page, and especially if it's private, if it's not public access, the employer cannot do anything to you. There is a statute in effect in about 28 states. I'm not sure where Connecticut stands right now. I don't think we have it here yet. But 27 states have adopted this statute that prohibits an employer from requiring an employee to give them the passwords to their personal social media pages as a condition of employment, unless they suspect criminal activity, in which case they have to have a court order. They have to have a warrant. But except for that, an employer, at least in these 27 states, cannot require an employee to hand over their passwords to their personal social media sites. That's considered a violation of their privacy. They can definitely require them to hand over any passwords that they use for the company website or the company social media pages. See, a lot has to do with who owns the social media page. A lot of these cases go different ways because of who owns the website. So, for example, if the company provides virtually all the smartphone cases that have to do with invasion of privacy on smartphones, the whole question is who provided the employee with the smartphone. If the smartphone was provided to the employee by the employer for use in their job to facilitate their job duties, then the employee can almost always be disciplined for whatever they do there. So, for example, the Kwan case. This was a Supreme Court case from 2013. The city of Ontario, California, lovely place actually, very suburban, kind of like Santa Barbara, basically gave all of their police officers smartphones so that they can communicate with each other in real time. Well, of course, what did these police officers do during their spare time? They went to a bar and they started looking at porn on their smartphones, and they were all fired, went all the way to the Supreme Court, and the Supreme Court said that because the town had provided them with those smartphones could only be used for workplace things. They could not use them for anything, anything personal, except maybe like a family emergency or something like that, and they lost that case. So that's the rule on smartphones. What employers should do: develop a social media use policy, make sure you update it regularly, because this is a very fast-changing area of the law. The law moves very quickly in this area. Make sure that you host a meeting with the employees to understand the policy and what you're supposed to do. Be sure that the employee acknowledges in writing having read and understood the policy, and when you fire someone, have the terminated employee acknowledge their responsibility not to violate the policy after they're terminated. You don't want a disgruntled employee who thinks he's been fired wrongfully is very likely to go on social media and say some nasty things about his ex-employer. And if he doesn't do it properly, he may end up getting sued for libel, slander, whatever. Okay, last but not least, then we'll take some questions. I'll answer some of the questions in the chat room. I see there's a whole bunch of them here, but I wanted to get through at least the main content. Should you post specific content to a social media website? I always advise people to use the political opponent test. And what a great time to do this with the presidential election coming up next month. Ask yourself, before you put something in a public place online, ask yourself the following question. If you ever were to run for public office and your opponent's campaign got a hold of this posting, would you be concerned? If the answer is yes, do not post. If the answer is maybe, do not post. If the answer is no, sleep on it. Think about it. Let it sit overnight. Look at it with a fresh eye in the morning. When in doubt, don't post. It's simple. Once you put something in a public place online, it stays there forever, and anybody who can use it against you will take the opportunity to do so. So, here are a couple of my best-selling books here. The Small Business Survival Guide is a collection of my columns that I write every week, which, by the way, if you're interested in my column, it's available online for free. You go to succeedinginyourbusiness.com. Every Monday, usually the column posts there. You can also get it at the website for Creators Syndicate, which is www.creators.com. It's totally free. In fact, you can do an RSS feed on my website where it notifies you when the new column posts every Monday. For those of you here who sell on eBay, this is probably the best-selling tax and legal guide you will find specifically for eBay sellers. I'm in the process of updating this for people who sell on Amazon and other websites. But this is still good stuff for eBay sellers. And here is everything, all the information you never wanted to know about Cliff Ennico. I do, in fact, look like that. I'm trying to lose some weight, but that's another story for another day. Now what I'd like to do is I'd like to open the floor to questions. What I will do, there is one question I want to talk about. I see a couple of people ask questions about the fair use doctrine in copyright law, and I want to just say a word to that. If someone sues you for copyright infringement, there is a defense that's available called fair use. This is the doctrine that got most of us through college without being sued. Whenever we did a term paper and we quoted extensively from another source, the rule basically says that as long as you footnote it and give credit to the author and don't try to claim it for yourself, under certain circumstances, that would not be copyright infringement. The fair use doctrine is one of the most difficult doctrines in all of law. There is no bright line test as to whether something is fair use or not. Certainly some things go into the public domain. Copyrights are not forever. Copyrights do expire after a while, but they last a very long time. For works that are created now, for example, in 2016, if I write an article today, the copyright on that article will continue for my life plus 75 years. That means if I were to drop dead now, you wouldn't be able to use that article without my estate's permission until 2091, which is a long time from now. So be careful. A lot of stuff from the 1920s, 1930s, people say, "Oh, it's that old. It's got to be public domain." Don't assume that. You have to look into this. There are websites. I do have a video on my YouTube channel called Copyright Basics, where I talk about this stuff and how do you go about finding out whether somebody owns something. How do you find out if Getty Images is the owner of that photo? I actually have a bunch of slides in that presentation where I talk about. I give you some resources. I would definitely refer you to that, but don't assume that something is fair use. The burden is on you to prove that something is fair use. If you get a nasty letter saying, "Hey, you're infringing my stuff, take it down," the burden is on you to show that you have the fair use, and most of the time the answer will be no. In all of my articles that appear on my website, I actually do have Google alerts on all of them. I have certain little phrases that I use in all my articles, and I use Google alerts on those. So if someone else has taken that article and is trying to rip me off, I will know about it. You will get a nasty letter from me. And I know attorneys in virtually every state of the union who owe me favors. So you don't want to steal Cliff Ennico's stuff. I'm sort of in that same league as Getty Images. So with that, look, I'm a nice guy, but don't steal my stuff, okay? That's all I'm asking for. All right. Steve, Budley, questions from the crowd?
Yeah, Cliff, thanks. And we're a little bit over about by the amount that we were at dead time. But there were two other questions I'll jump on. You answered Kelly Her's question on avoiding copyright infringement, and she said thank you for that. So that was good. I've got back at the beginning earlier, there was Robert Schulten, who I see is still on, said, "I'm a seller of beverage alcohol. I extensively use Facebook to raise awareness of my brand. What are the legal pitfalls?"
Oh, wow.
I think you kind of talked about this, but it's a big question. Right?
Okay. Well, as you know, the alcohol rules are Byzantine in their complexity. It is not yet the case that you can sell alcohol everywhere in the country without having to comply with certain state laws. The advice that I normally give to people in this situation is, by all means, promote your brand as you would, but make sure that you include standard language to say that the beverages may not be available in certain places. Buyers must be at least 21 years of age or older. If you look at other alcohol-related advertising, this is actually kind of a gray area because, as you know, alcohol advertising is mostly prohibited now. There's a movement now to sort of ban alcohol advertising, on TV and radio and stuff like that. The whole area about what you can and cannot say about alcoholic beverages is rather Byzantine right now in its complexity. You can certainly promote your brand, but you got to be very careful to make sure that it's in an appropriate venue. So, for example, promoting your brand on a children's website or on a website that can easily be accessed by people under the age of 13 is not going to be viewed very, very favorably by most people. So it's a difficult question. I can't really answer it in 5 minutes or less. I would encourage Robert to reach out to me directly if he wants some more one-on-one advice there. That's a very peculiar situation.
Mm-hmm. Okay, so one last one, Cliff, from Marlene Rios. In regards to promoting your business on SM, social media, does Facebook own the work made for hire as well?
Okay, the short answer is the work made for hire doesn't apply to the stuff that you post on Facebook. That applies more in the context of people who do posting for you. So if I hire you, Steve, to do my Facebook page and keep it updated every week because I don't have the time for it, whether you are an employee or an independent contractor will determine who owns the content. And that's the question that I was barking at. What you do have to realize, though, is that whatever you post on Facebook, technically they own the rights to it. So if they want to do a collection of the 1,000 funniest and most ridiculous Facebook posts ever, and yours is one of the ones they select for the book, there's not a whole lot you can do about that. You gave them permission by posting the content on Facebook. That's what I was barking at there. And if you're an artist or a photographer, that can get really sticky because technically Facebook would have the right to reproduce your. Not everybody else, by the way. The rule only applies to Facebook. It doesn't mean anyone from Facebook, anyone who happens to see your posting with your artwork can rip you off. It doesn't say that. It just says that they can use it. That Facebook Inc. can use your content in ways that you might not like, and there's nothing you can do about that. So I advise my artist and photographer clients just not to, by all means, promote your stuff on Facebook, but don't put the actual reproduction up there unless it is so watermarked. And I mean, there are ways that you can encrypt something so people cannot make copies of it. I confess I'm not an expert on these things, but there are ways you can do it. And if Facebook will allow you to do that, then by all means take advantage of that.
Okay, good answer, great. So listen, this is all the time we have today. Thanks very, very much, Cliff. That was a lot of information in a short period of time, and to everybody, including Cliff, I apologize for the delay or the dead.
I have to say, by the way, in 36 years of practicing law, that's the longest I have ever been silent is 9 minutes. So
yeah, well, it was even longer.
This is a historic occasion. An attorney actually went 9 minutes without saying anything. That's got to be one for the Guinness Book,
Yeah. Okay. So just one other thing. I said it before, but on October 25th, we'll have another webinar, Marketing to Your Mobile Customers with Kate Berg. You can get the details of that on scorefairfieldcounty.org. And you should also just go there anyway to see the full list of things that we have to offer. A lot of really good stuff. So on behalf of SCORE, thanks everybody for attending today. Thanks again to Cliff. Please join us for our next webinar on the 25th. And back to your busy days. Thank you very much. Bye-bye.